Well, welcome everyone to Women on Wealth. And I am really excited for this podcast today because I already know I'm going to learn something. I know the listeners are going to learn something. And the conversation is going to revolve around digital assets in your succession plan. And so to have this conversation, I have two experts in the field. They are attorneys at Davis Gilbert based out of New York City. First, I have Herb Nass, who is one of the country's most sought after trust and estate lawyers. He has a 35-year career, which has earned him a reputation among high net worth and celebrity families for smart planning and counseling, aimed to preserve their wealth and minimize tax obligations during transitional life events. Herb has been quoted in articles including Forbes magazine, and you have authored, Herb, the 100 Biggest Estate Planning Mistakes, which you were kind enough to provide me, which is very interesting, and Wills of the Rich and Famous. So welcome, Herb. We appreciate your time today.
Thank you.
And then also I have joining us Katherine Brennan, who supports high net worth individuals, multi-generational families, trust and business entities in their wealth planning goals, graduated summa cum laude at University of Miami School of Law. So we have a lot of expertise joining with us today. So appreciate it. And I have to say, Herb, when you and I first met and we talked about this idea, I had quite frankly never thought of it before. And then funny enough, one of my clients earlier this week is updating her power of attorney. And the first thing she said to me is, Jelena, did you know they're putting digital assets in my plan? And I said, this is perfect. So, and I think it's really representative of the fact that most individuals have never thought of this before. And so that's why I'm excited to get into this conversation. So before we go through, kind of what it is and how it works, can you first start with what are some questions that the listeners should be thinking about as we kind of have the discussion today?
Sure. In a moment, Katherine Brennan will define what digital assets are. But based on that definition, I think the first thing for a client to do is to list his or her digital assets, create an inventory. It's a new form of asset that didn't exist necessarily 20 or 30 years ago, but it exists now. And it's important that, like any other financial asset, the client have a comprehensive inventory list of his or her digital assets. Then the next question is, once you've determined what your assets are, how can you make sure that the beneficiaries of your estate will be able to access those assets? And that's a very difficult issue. This is a technical issue that Katherine will address later in our discussion, but that's very important. Unless you can access them, just like if you can't access a bank account, it's not available. So access is key.
Yep.
And along those lines, the question of who will manage those digital assets during your lifetime and after you pass away. During your lifetime, you can manage your own digital assets, but if you were disabled or missing or something else, you want a power of attorney that addresses this, that gives your agent the right to have access to those and be able to manage them on your behalf, the same way you'd want your executor of your will to be able to manage those after your passing. And then finally, how can you ensure the privacy of your assets if that's what you want? Many people have digital assets which they don't necessarily want their family to know about. So that's something to consider at the outset. And what mechanisms can you take advantage of to ensure your privacy related to those assets? So with that, I'm going to turn it over to Katherine, who will really describe what digital assets are.
Yeah, that would be great. I know that a lot of people are wondering that.
Yes. So, as we spend more and more time online, our digital footprint is just getting larger and larger. So we have a lot of files, photos, and accounts that really do reflect our lives online. I think it might be helpful just to start with a legal definition, since we're attorneys and we have to just provide one or two.
Of course.
So there is a model statute here that really has been almost universally adopted in the United States. It's been adopted in 46 countries, or 46 states, excuse me, and has been introduced in Massachusetts. And that's called the Revised Uniform Fiduciary Access to Digital Assets Act, which does not roll off the tongue at all. So everyone calls it RUFADA.
Rafada.
RUFADA. So
Okay.
RUFADA's definition of a digital asset is an electronic record in which an individual has a right or an interest. The term does not include an underlying asset or liability unless the asset or liability is itself a record. So we can maybe flesh out what real examples of these digital assets are, but it's really just generally your intangible digital property and your electronic communications. And we should just note before we kind of get into what these assets are, is that they may not all necessarily have a monetary value, but they oftentimes have a sentimental value to your loved ones and may also have some privacy concerns that you would maybe want to address in the event of your incapacity or death.
Okay. And I think that's what's so interesting too, because when people think about wills and their estate planning, they're thinking about it more from a monetary standpoint, but this does sort of drive more the emotional side, right?
Exactly.
Yeah.
Because when you have all of your photos of your vacation spent with people, your photos, I'm sure somebody may want all the photos of my dog at some point in my life. I don't know. But that's sort of encompassed in our personal digital assets, the things that are very close to us and maybe very important to our family members.
Great. Okay. Yeah. So let's talk a little bit about the different types of digital assets, if we can. If you can give us some examples.
Absolutely. Yeah. So I would say maybe we would probably break digital assets into four main categories. You do have your personal digital assets, which are your photos, your documents, maybe some things that you've created throughout time. It also maybe will include your, online loyalty rewards accounts and your gaming assets, your online avatars, if you're into that. That being said, if you remember the definition that RUFADA has, it says the term does not include an underlying asset or liability unless the asset or liability is itself an electronic record. So while we're talking about movie libraries, music libraries that we may personally own, we cannot necessarily transfer those at death. Usually there's a terms of service agreement, which we'll talk a little bit about later, which specifies that you really only have a license to those assets during your life. So you're not going to be transferring your iTunes library to your loved ones at your death because you may just not be allowed to do that.
Right.
Your social digital assets is another category, and that includes pretty much anything on your social media. The Instagram photos of vacations, the Facebook birthday posts and recommendations and questions, your TikToks you've created. And that's stuff that may not necessarily have monetary value unless you're a content creator, an influencer or something, but it may be something that you don't necessarily want to be sitting on the internet till kingdom come. And then your business digital assets can kind of tie into that, especially if you are a content creator, if you've created websites, blogs, if you have intellectual property online. This is sort of an emerging area, but it's, again, something where you're going to have usernames and passwords and some content that someone may need to access. Okay. And then the last category is probably the one that most people are concerned about, and that's your financial digital assets. That's your online banking accounts, your credit card accounts. Tax day was on Tuesday. It's your TurboTax with all of your tax records in it.
Yeah.
And like the iTunes libraries and those licensed assets, it's important to note for your financial digital assets that while the account itself is a digital asset and all of the statements and everything therein, all of that money that is held in those accounts is actually considered a financial asset and would pass under separate terms of your estate planning documents. And that's the same for cryptocurrency and Bitcoin as well.
And
I think the point Katherine is making is the underlying financial asset itself is not considered a digital asset.
Yes.
That would pass pursuant to other clauses of your will that would deal with financial assets.
And one of the things I'm thinking of, which is why I was so interested in having this conversation today too, is I have a friend, Herb, I think I mentioned this to you, who lost his wife about 5 years ago. And when she passed, all of their passwords for access to almost everything was on her iPad. And he didn't have the password to the iPad. And so he had to go through Apple, and it took him forever to get access to all of that. So this falls under, it seems so simple, but it was devastating, to kind of go through the process after the fact.
Well, that's right. And the biggest challenge is often accessing the assets after a person dies. And that's something that a husband and wife or a beneficiary of an estate needs to discuss with the testator and get a list. Maybe we go back to paper in this respect.
Yeah.
And have a paper list of passwords and access codes, et cetera, et cetera.
Mm.
One other alternative is for the person with the password list to email that to the other person. That way he or she has access, because if it's only in the decedent's iPad or phone, the problem is getting access to it. And I think it's worth a husband and wife sitting down and really discussing this and making sure that each of them has the initial access to the other one's assets. I know my wife is very careful about this, and she has a list of my passwords on her phone so that she could access that. And I feel better knowing that she does have access to that.
No, absolutely. And everyone's so sensitive about their passwords these days, but at some point we do need to share it with someone, right?
That's right. And maybe also send a copy of it to your attorney to keep in your file in his or her office. And that way, if your spouse is not available, then at least the attorney has it. Maybe you don't want to give it to your children, but you certainly should give it to a third party or your accountant or someone else who can just hold it either online or in your file in a hard copy.
Yeah, that's a great idea. Thank you. And so what are some other challenges in terms of accessing these assets? What else comes to mind?
Well, I think just to sort of piggyback off of this discussion about the sharing of passwords and login information, is that there is a very important nuance that custodians of digital assets. So when we say custodians, it's Google, Apple, Twitter, any of these websites, companies that hold this information. All of these custodians have terms of service agreements that everyone will sign, that we all, of course, read every single detail of before we sign up for an account. But these terms of service agreements typically will prohibit third parties from logging into individuals' accounts, either during their life or at their death. It's actually considered illegal. It's considered to be a felony in order to do that. So
unless the agreement has allowed someone else to log in.
Exactly. Okay. Which is becoming more and more the case as there's this new tool online called legacy contacts or inactive account managers that Google has, that Apple has actually. I think all of the metaverse, so Instagram and Facebook have this, Twitter have this as well, that you can delegate someone who has access in the event of your death or in the event of an extended period of inactivity on your account. So there are some remedies to that. It's just something to keep in mind. So rather than necessarily logging into someone's account just blindly, there are now also through RUFADA, having been adopted in a lot of states, ways for you to be able to request access to someone's digital assets. But to Herb's point and to your point, it can be a very difficult process. The custodians of these assets may require a court order showing cause that you have the authority to be able to access these accounts.
So I recently had an estate in Connecticut where the decedent died, and his wife was eager to get access to his emails and digital information, but she had no password, no information. Fortunately, the will we had drafted for him had very express language in it that allowed the executor to get access to the property, to the digital property. And not every will has that. Certainly older wills don't, but that's an important point, and Catherine will get into this more in a little while, specific language should be in the will authorizing the executor or not to have access. So this decedent's widow wanted access, particularly to his Apple information, and Apple required a court order. So we went to probate court in Westport, and it was because we had express language in his will authorizing this that it was a much easier process. So we did get a court order. Connecticut courts are very willing to meet with petitioners on various issues, and the judge at that point signed the court order on the spot once we explained that the decedent's widow wanted to, get access to his bills on digital, in his digital accounts, and there were a variety of good reasons that she wanted access. So we got the court order, and I will say, even with the court order, Apple was not that easy to deal with, and they have their own rules, and they're a huge corporation, and court order, they ask for it, but it doesn't always do the trick. Ultimately, she got access because the will had express language allowing it. Apple was comfortable that they weren't revealing they weren't violating privacy concerns of the decedent, and that's the balance.
Sure.
Maybe things that a decedent doesn't want his heirs to know about. It happens all the time. Yeah. And in the terms of service agreement, the TOSA is the acronym. A person can also say that upon his or her death that the account should be deleted and not made accessible. So in my opinion, those TOSAs are very important. I think clients should look at those first and see if there's tools within the website of the custodian that allow the client to designate what he or she wants to happen upon his or her demise, and not rely on the will, but rely on Apple or Google's own agreement that they'll be comfortable relying upon once it's been properly completed.
Okay. And it is really interesting to hear. I'm not picking on Apple, but I think most of the listeners have some type of Apple device. So I think it is important that they do, to your point, Herb, they have their own set of rules, and they are strict. My friend went through the exact same thing trying to access his wife's iPad. So I think this is important for people to know. And can I make an assumption that if someone hasn't looked at their will or updated their will in, say, 10 years, that they don't have any of this included in their will?
I think that's a fair assumption. Probably about 10 years ago is when estate planners who were cognizant of digital assets started including provisions.
Okay.
The decedent I referred to, we had done his will in 2016, and so at that point, it was still, we were adding it at that point.
Well, and I know that your firm was at the forefront of this. So that's, I think this is why it's such an important topic. So that's great. And with the growth of all of this and the inclusion in the succession planning, the importance of this, what can you talk about legally that's been done to address it? I know, Catherine, you were talking about some of the regulation earlier, but can you go a little bit more detail into that?
Yeah, absolutely. So with the statutes that are in Connecticut and New York that all have adopted this language of rufata, it really does provide several different frameworks in which to obtain access to a decedent's digital assets. In order to gain access, though, you have to be the fiduciary here. You have to be either an executor or a trustee or the administrator of an estate. It can't just be a loved one who is just emailing saying, I'd really love access to my deceased husband's photos. Can I please obtain them? It has to be someone who is in charge of the estate of that person, who is either reaching out in writing to the custodians requesting access per the terms of the TOSAs, or ideally, if the decedent has included this language in their will, to provide the executor the most broad discretion possible to dispose of the digital assets, which is what we typically like to include. We like to make it as broad as possible to give them the most flexibility to kind of know how to handle all the digital assets, because you never know when the will's drafted versus what is available
Sure.
now. I mean, AI didn't really exist more than 2 years ago, and it's something that we sort of need to put into consideration now. So the language in the wills is really what we try to emphasize to clients the most and always include, because it really can make the life of the executor or the fiduciary a lot easier.
Okay.
All that being said, Rufata, and as it's been adopted by the majority of states, does have a very specific nuance in terms of access if you don't specifically provide otherwise in your will. So the
Okay.
default rule is for electronic communications, an executor can have access to the quote unquote catalog of those electronic communications. So emails, digital messages, kind of everything that you would consider to be private.
Okay.
You don't automatically have access to the content of those emails, those digital messages, which is really the intent behind that was to really balance the privacy interests of a decedent who didn't specify anything. You know,
Sure.
if they didn't say anything to that effect, you don't want to assume that someone should just have free reign to be able to access all of their digital records unfettered.
Okay.
So that's, again, it's important that we include language depending on what our clients want, so to make it clear that and easier for the executor to be able to access what they need while still respecting our client's privacy where needed.
Exactly. Okay.
But that's a very important distinction, the catalog versus the content. You know,
Yes.
having a list of the emails sent is helpful, but it doesn't provide what the email said.
Mhm.
Yeah.
It's very important that the access that the court-appointed fiduciary has includes access to the content as well as just the list of communications.
Okay.
Very
No, that's great. Thank you for the clarity. And have there been some case studies since all of this came about that you can reference?
Yeah, actually, a lot of the case law has come out of New York, oddly enough. It just seems to be at the forefront of a lot of rulings on it.
Yeah.
And most of these cases actually pertain to that distinction between a catalog and the content of someone's digital life online.
Oh, okay.
Yeah, so there was a really sad case that came out of Westchester County in 2019. And it was this 24-year-old young man who passed away, I believe, like right around Christmas time. And he did not have a will. And his parents were appointed as administrators of his estate. And they went to court and said, we need access to his phone. We can't access, just like your friend.
Yep.
We need access to his phone. We need access to his iCloud, because he's 24. He probably wasn't communicating about, what was going on in his life. And they probably also just wanted some of those things for sentimental value.
Sure. Yeah.
The court said that they really needed to show more cause in order to be able to access his iCloud. They denied any sort of access to them because his privacy concern at that point outweighed what they were able to show as the need on their part to administer his estate. So
Okay.
Because he didn't have a will that would have said that they have the right to have access.
exactly.
Dying without a will is problematic when it comes to digital assets because there's no instruction in the will.
And I have to imagine most parents would just assume that they would have access to this.
Exactly. Yeah, exactly. You would think that it would just be, and that's not to say, again, the court even noted in there that it doesn't mean that access is fully prohibited, that if they could show cause that they
Right.
needed access to this in order to properly marshal any sort of assets in his estate.
Right.
Because more and more, everything is just tied into your online identity, your
Yeah.
financial. It's because if you can at least see a catalog of emails, you can kind of know, all right, well, he was receiving notifications from Wells Fargo. So maybe we should probably reach out to Wells Fargo to see if he has anything there. It really
Right.
can provide a guidepost now for what a person owns.
But the court basically said sentimental value is not enough.
Exactly.
Correct.
Exactly. And there's been other cases too, where they really have drawn the distinction where there was one case in New York that someone wanted to get the emails, the contacts, and the calendar of a decedent. And they said, okay, well, you can have the calendar and you can have the contacts, you can't have the emails because it didn't specify in their will that you had a right to access those emails. So because that falls into the content category, you only get the catalog of information that can be provided from contact information and
Sure.
your calendar.
And this is highlights why it's important to have a will once a person turns 18. I think a court would distinguish between a child who dies who's under 18 versus over 18. As the legal guardian of the children, the natural guardian when they're under 18, the court would be more willing to give the parents access to a minor child than to a child over 18. So just like we advise clients to have their 18-year-old plus children have living wills, healthcare proxies, powers of attorney, this is also a good reason to have a will. Even if the child doesn't have significant financial assets, having a will would expressly allow the parents to have access to his or her digital assets after death. So a good reason to encourage that for the next generation.
Yeah, I think that the next generation, I'm thinking of my daughter who just turned 14. I have to imagine that she will want to have a say in her digital assets when she turns 18 and who is accessing her Instagram and TikTok, et cetera. So yeah.
Absolutely. Because sometimes people do have the privacy concerns as well. And that's the importance of doing that audit and looking to see what your accounts are and designating, all right, what do I want to happen to this at my death? Do I want someone to be able to access this, or do I want it to be automatically deleted at my death?
Yeah. And I think the other important comment I'll make is that I am still shocked as to how many adults I come across and meet that do not have a will or a power of attorney or a healthcare proxy. And we talk about the importance of it. And I think this is just adding on to that importance. So it's a great point. So what can we do to protect these digital assets? Can we talk a little bit more about that?
Yeah, absolutely. So, we've really been emphasizing this review of your digital assets. It's, with anything with estate planning, it's really important to get a good grasp of what your assets are, so you know how to account for them at your death and really feel empowered that they are going how you would like them to go.
Mm-hmm.
So as part of the audit, you want to include the usernames and passwords, the login information. If you have cryptocurrency, please include the instructions on how to access the cryptocurrency, because it can be very challenging, as we've found out over time. And a good way to just do this is, you can go into Apple on your phone and look and see what your subscriptions are. You can kind of go through and list off all of your banking accounts that you know that you have, and your investment management accounts that you know that you have. And I know I use the password manager through Google to save all of my passwords. A lot of people do that. Just, spend an afternoon, go through and see everything that you have saved and write down, delete this. I have files on this account. Please transfer them. Please give all of my photos to my spouse, to my children. Be as specific as you can be, so that it really gives your executor guidance at your death or in the event of your incapacity. If you have this list and you give it to your attorney, your spouse, whoever it may be, if you're incapacitated, then under the power of attorney, they can go in and look at these assets and be like, okay, she may not need her Netflix account right now. Maybe we can put a pause on that for a little while. And anything that may be just an unnecessary cost for a while, it just helps in managing assets and just being a little bit more efficient.
Okay, that's a great idea.
Yeah.
And so once you've compiled that list of, you've audited your digital assets and have a list, the next question is where to store that list and who should have access to it. Yeah. So that's where maybe we go back to paper and you put your list in your safe deposit box so that it is accessible after your demise, but not necessarily during your lifetime, or make it available during your lifetime.
Yep.
Yeah. And we've had some clients who have kept a list of not just their digital assets, but sort of all of their accounts with their estate planning documents. So because, it's so stressful when someone passes away and the family's usually thinking about other things.
Exactly.
So for us to come in and to be able to say, here's the list of assets, when you get a chance, you can start going through these and just reaching out to the custodians as needed. It makes the process less stressful, and it takes some of the work out of the family members to have to go looking for that piece of paper.
Okay. No, that's great. And so we talked a lot about through the conversation about the wills and the power of attorney. And, there's all of these moving pieces when it comes to estate planning. Who typically handles this? Because we talked about a few different roles along the way.
Well, if your power of attorney allows your agent to have access to your digital assets, then the agent would, if he or she is using the power of attorney.
Okay.
Power of attorney could be structured so that it springs into effect if something happens, or it could be effective at the time the principal signs it. And then
Right.
in your will, of course, you want to name an executor, and Katherine can speak to the concept of a digital executor, who might want to pick that up, Katherine.
Yeah. So a digital executor is, just to be clear, it's someone that you could appoint under the will in a more unofficial capacity. You're not going to be appointed by the court as a quote unquote digital executor. But your estate planning documents can be drafted to say that, this person is appointed as executor to handle the disposition of my digital assets. And then we'll include our language in there outlining, the broad scope of authority that they have to manage and dispose of those assets. The reason that you may want to have a digital executor rather than just the one executor who handles everything is they may not necessarily have the necessary knowledge or expertise to manage those assets.
Okay.
I know I love my parents to death. I don't know if my mom or my dad would necessarily know how to go through that full process online to be able to shut down accounts and transfer assets out as needed.
Yeah.
So you may want to think about maybe having someone that has a little bit more of a digital expertise for that role, particularly if you have a large online presence.
Okay. It might be more of a generational thing.
That's right.
Exactly.
Or alternatively, it may be that you don't want your executor, your general executor, to have access to your digital assets, and you want to limit that to just a specific person whose role is limited to that. And often, I think Apple wanted to see a copy of the will that we had prepared for that decedent, and they then could see that the executor had broad authority and that there was no other person who was in charge of digital assets alone. So that ultimately gave them comfort that they could reveal this information to the named executor who was appointed by the court.
Okay. Oh, interesting. So, and I think what I'm hearing here is that there is a lot of flexibility. But I think the most important thing is that you want to be the one to make that decision, right? Not the court.
Exactly.
And this is especially with such an emotional tie, I think that we all have to so much of these digital assets. So thank you for going through all that. I have to say, I knew I was going to learn something, but I've already made a couple of points here that I need to go personally and check on my own. So,
well, maybe if I could just ask Katherine to maybe just read the language that we include in our wills.
that'd be great.
Quite broad, that allows the digital executor or the executor to have access.
Yeah,
please. I have it in front of me. So the language we include is, in addition to and without in any way limiting any powers or authority which my executors would have in the absence of this article, I authorize my executors in respect of my estate and any funds held under this will at any time and from time to time and in their absolute discretion to access, handle, distribute, and dispose of my digital assets, which includes creating an inventory of online accounts, changing passwords to protect identity and prevent theft, backing up data on an external media, consolidating, distributing, or destroying contents of the accounts, valuing the assets for estate tax purposes, deleting secret accounts, cleaning up devices, and clearing all devices as appropriate under the circumstances.
Wow. Okay.
Yeah, so it's broad and it should be. Now,
Yes.
that language about valuing the assets for estate tax purposes, that hasn't really come up yet where we've had to put on an estate tax return of the value of a particular account. But over time, it will. Expect,
Yeah.
Catherine, like an NFT has value. And if a person has that as a digital assets,
Sure.
asset, that may need to be included on the estate tax return.
Okay. I would encourage anyone listening that if they have a will, they should go and take a look and see if this type of language is in there. I'm going to assume it probably is not. And if you don't have a will, I highly recommend you consider, you're not the first ones to come on this podcast and talk about the importance of having a will, but if, let's hammer it home one more time and hopefully people will consider, especially after this discussion. So where can people find you if they have questions or want to learn more?
So we work at Davis and Gilbert, based at 1675 Broadway in Manhattan. We have email addresses, of course. That's a digital asset, I suspect. kbrennan@dglaw.com and hnass@dglaw.com. That's certainly a way to contact us, and we'd be happy to discuss this further with any of your listeners.
We appreciate you sharing your expertise. I don't think that all law firms are focusing on this to the extent that you all are. So thank you for being leaders in such a change and shift in our generations moving forward. I think this is going to be incredibly important. So I look forward to hearing future conversations from you about other important features that should be added to the wills.
Good.
Thank you so much.
Thank
It's
you,
been such a
Julia.
pleasure.
Pleasure. Have a good one.